had a conflict tonight. So Michael is going to be a one-man show. And Michael is the founder of Liner Legal Disability Lawyers. They're based in Cleveland. And he has been successfully represented thousands of claimants seeking Social Security disability benefits at all stages of litigation, from initial applications up through the federal district court level. We have been lucky to have Michael as a guest speaker in the past, and I know that you're all really excited to hear what he's got to share with us tonight. So welcome, Michael.
Thank you, Charlotte. I'm excited to be back. And I appreciate the introduction. I'm also excited to hear that one of those light up the buildings is going to happen in Cleveland, where I am. So that's something that I'm definitely going to have to check out.
Yeah, we're excited.
Yeah, so, we did this webinar, I think it was almost about 2 years ago. And we had such a great response that I'm excited that you guys asked me to come back and speak again. We're unfortunately tonight limited to about an hour of time, but I'm going to say this probably several times tonight, but I will encourage you, even though there's time at the end for questions, I'm already seeing over 80 people in here, that there may be more questions than we have time to get to all of them. Don't be a stranger, reach out to me. I'm happy to answer them. I love serving the Dysautonomia community. And I think that, there's a lot of unanswered questions that I want to make sure you all get answered correctly. So please feel free to reach out to me. I am going to share my screen and kind of jump into this. Is that okay, Charlotte?
That's perfect.
Okay. So Social Security, the down and the dirty. In the synopsis for this presentation that went out, I think there's a key element to it. And I think that the description in it is so important because impairments involving dysautonomia are misunderstood by the legal community, disability adjudicators and judges in particular. And there's no better example of that or comparison than how long it takes so many people who have a dysautonomia diagnosis to be diagnosed. And even when you're dealing with your doctors, it takes so long to get to a proper diagnosis. So it makes sense that if doctors can't even, understand it and understand the symptoms and how it affects people, that why would a bunch of lawyers and judges get it any better than the medical community does? And I hope to spend some time today answering, I'm guessing what many of you are would want to know. And I want to try and address, things that you can do to improve your chances of winning a disability case on first impression, or helping you keep the benefits, because there's two things. I'm going to talk through the process a little bit. I might skip around in the slides a little bit because I really do want to leave as much time at the end as possible to answer your questions. But there is just so much. It's not just important that you do the things that I'm going to tell you about before you're receiving the benefits to get them. It's important that you continue to do them to maintain the benefits, because Social Security, even if you're approved, will continue to analyze the case. So Charlotte already gave a nice introduction, just a little bit more background, but I'm not going to spend a ton of time here. I got into doing this type of work because I myself live with several impairments. I went to a special school for children with ADHD. I had epilepsy when I was a child that thankfully I grew out of, but as an adult, I live with motor tic syndrome and cluster headaches. So the reason that I went into this type of work is I'm very lucky. I'm grateful that the treatment that has been offered to me for the health issues that I have has stabilized my conditions enough that I can work. But I'll tell you, when I have a cluster headache, you're not going to reach me. And I get what it's like. You know, not everybody's fortunate to be self-employed and have a business and employees that they can lean on to help them. So I get the reality of trying to work with different disabilities. And that's what drives me every day. And then you see what I work for. There's no better purpose than my kids, Eliana and Dylan, who he's not 5. If you were to ask him, he'd make sure you know he's 5.5. So the things that we're going to talk about, I'm going to be real quick in kind of going through, you know, what is Social Security disability. I'm going to kind of describe for you the differences between the disability programs, because there's 2 different programs that Social Security offers. Really, there's 5 types of disability benefits, but 2 main ones that we'll spend our time on. And then I'm going to talk to you about, like what I said, what I think the most important things for you to do to either receive disability benefits or maintain benefits if you're already receiving them. Actually, this number 4, I don't think we're going to talk about this. Most important aspects of hiring a disability attorney, and I apologize. I think that this slide was on a presentation that I gave for the foundation a few years ago. That was something that they asked me to specifically present about. If you have questions about the aspects of hiring a disability attorney, I would tell you, feel free to put a question in the chat or reach out to me directly, but I don't want to take time away from people and really talking about the meat of this presentation, because I think last time we had an hour and a half. I only have an hour today with questions. So I want to really focus on what I think you should do to improve your chances of being successful at the process. So here's the biggie, and this is a mouthful. I'm going to try and make this a little easier to understand, but what is Social Security disability? It is a government benefit. It's administered by the Social Security Administration for people who are unable to engage in any substantial gainful activity. I'm going to come back and explain what that is. By reason of any medically determinable physical or mental impairments. That's the second important piece to this definition. And finally, which can be expected to result in death, or which has lasted or can be expected to last for a continuous period of not less than 12 months. Okay. So the first important piece of this definition is that SGA piece there, substantial gainful activity. What does that mean? In order to receive disability benefits, you don't have to be totally unemployed. You also can't apply if you are working full-time, but more important than the number of hours, it's about an amount of money. You are unable to apply or receive disability benefits if you are working and receiving more than, and this is a number for 2022 only, so this is an update if you saw me speak a few years ago, $1,350 per month. That is what SGA is. If you are unable to work and earn $1,350 a month, then that's what they're looking at. That number goes up every year. And it doesn't matter if somebody is working at a company that pays them $2,000 per hour and they work 1 hour of the month. And people scratch their heads when I tell them this, but it really is just about an amount of money. There's a little bit different rules if you're self-employed, but you know, in most circumstances, we're dealing with people that are employed in the outside world. If in 1 hour you earn $2,000 for every hour, you know, 1 hour that you worked, but you did that every month, you would be unable to collect Social Security disability, even if you were consistently only able to work 1 hour a month because of your impairments. The next piece that's here is by reason of any medically determinable physical or mental impairment. So you have to prove that you have what Social Security calls a severe impairment in order to receive disability benefits. You don't need to, it can be, you know, a dysautonomia impairment or disorder. It could be a mental health impairment. it's really, but what I like to make sure people understand, this is kind of a tip for that'll probably come out again later, is when you are filing for disability, don't only list, and when you're trying to keep your benefits, don't only list what you consider your primary impairments, like I have POTS. And so that's all I'm going to put because I want them to really focus on my POTS. List everything, because every impairment that you have can create additional limitations that reduce what Social Security calls a residual functional capacity, which is a mouthful of a term, but I'll put it in layman's terms. Residual functional capacity means what you can and can't do. And every additional limitation that's added into, the disability soup, if we were to envision it that way, somebody who maybe their primary severe impairment is POTS. And so, they need to be very slow with transitions. They need to, perhaps they have to keep their legs elevated for a significant part of the day. But they should also list the fact that if they're experiencing a depression or anxiety disorder, that further adds additional restrictions, like, they struggle mentally to interact with other people because they feel more reclusive. Every little bit helps towards eliminating jobs. And with Social Security, what we do have to prove is that there's no work that exists in significant numbers in the entire national economy that can be done. But the more impairments you have, the better the chance of being able to reduce work. So don't just list your primary impairment, list it all. And then the final piece here, it's the durational requirement, which can be expected to result in death, or which has lasted or expected to last for a continuous period of not less than 12 months. To the attendees of this webinar, I would say that third prong there probably is an automatic. If you are here either as somebody who has dysautonomia or somebody who is supporting someone, I mean, that's not an impairment that when you're diagnosed with it, it's expected to disappear, resolve in 6 months. A better example of why they have this durational requirement, for example, somebody breaks their legs, they break their knees. And there might be a period of time when they're going through therapy, surgery, treatment thereafter that they can't work. But if they are able to regain some level of functioning to do some jobs within 12 months of that acute injury, they wouldn't meet the requirements for disability. Cancer cases, I see this come up in cancer cases a lot, where there's many forms of cancer, particularly if you're diagnosed early, as scary as it is, where from diagnosis to remission is far less than a year. And that period of time that you can't work, it's really challenging. But in order to receive these benefits from Social Security, you have to have an impairment that has lasted or will last at least 12 continuous months. Okay, so there's 3 pieces there. The next thing, and again, this is kind of a text-heavy slide, but I want to explain the 2 main programs that Social Security offers. There's SSDI, Social Security Disability Insurance Benefits, and then there's SSI benefits, Supplemental Security Income. The first benefit, SSDI, it's based on on your years and quarters of working and paying into Social Security. So when somebody is employed in a position where they are, your Social Security taxes are coming out of every paycheck, or even if you're self-employed and you just pay your Social Security taxes once at the end of the year, whatever the case may be, those are called FICA taxes. Some people call them FICA taxes, but most of that money, I think 6.7% of your earnings that you get taxed on goes towards the Social Security retirement program. However, there's a smaller amount that's about 1% that actually goes towards the disability program. Everybody's paying it. I'm paying it. And if you eventually become disabled and unable to work, it's like an insurance policy. It's an insurance policy that many people don't realize they have. But there's other elements of the SSDI program that make it similar to insurance, like, for example, the fact that you have to have a recent work history to pay in, sort of like car insurance, right? So I'll explain the general rule here. You need, for people who are under the age of 32, the numbers here are a little bit different, but let's, just so I can be square with everyone. Generally speaking, people had to have worked in and paid into Social Security for 40 quarters of the last, or for 20 quarters of the previous 40 quarters. What that really breaks down to, the easier way to say it is, you have to have paid into Social Security for 5 of the 10 years immediately prior to becoming disabled. After you can no longer look in the rearview mirror and say that you have paid into Social Security for 5 of the previous 10 years before becoming disabled, your insurance for disability has lapsed. Frustrates many people. There's many people who are caught in a catch-22 where they did pay into Social Security for a while, but maybe they did something else, or they were unemployed for a period of time, and ultimately, when they went to apply for disability, they were unable to because their insurance had lapsed. It's like car insurance. Now is a better time to start bringing that analogy. While you're paying your premiums every month, you continue to be insured. But if you go a while without paying your premium, then eventually your car insurance will lapse. Similar concept. SSDI benefits come with Medicare. Makes sense, right? Just like retirement benefits come with Medicare, so does disability insurance benefits. And a good way to think of SSDI benefits, especially in terms of how much somebody's going to receive, is it's like collecting your retirement benefits early, your full retirement benefit early. So those numbers are usually very similar. How much somebody would receive if they, retired at, now it's 66 in a few months, and what they would receive if they're awarded SSDI benefits. One thing I want to comment about Medicare, to explain the parentheses that are on there: you must be in a pay status with Social Security for 24 months before you're eligible to receive Medicare. So it's not, when you turn 65, people are automatically eligible to receive Medicare. Disability works a little bit different. With disability benefits, you need to be in a pay status, meaning you've been receiving a check, or back payment months for Social Security are included. But you've got to be in a pay status with Social Security for 24 months before they will grant Medicare. It does create a problem for some people who then have, even if they're awarded right away, they realize they're not going to be covered with government medical insurance if they don't have Medicaid for potentially a few years. The amount that, just like retirement benefits, the amount that you receive from disability, it's based on how much you were earning, how long you were earning for, and the taxes that you paid in through your earnings, those FICA taxes. And one thing about disability benefits, I'm going to add one to this: you can actually receive back pay up to 12 months prior to applying, if you demonstrate that you were disabled longer. So that there's many times where somebody you're having a lot of symptoms and you're going to the doctor, and you're not applying for disability because you're going to the doctor, hoping that you get better. And a year of appointments and all these other things go by, and then you're finally like, wow, I'm getting nowhere with this. So you decide to apply for disability. If you have the appropriate quarters of coverage, if you're insured for disability, you can actually receive back payments before you even did the application. The other thing that I want to add about SSDI benefits, because I think this is really important, it's a question that I hear all the time, is SSDI benefits come with dependent benefits. So if you have children who are 18 or younger, or actually 19 if they're still in high school, up until they turn 19 while they're still in high school, your children can receive extra benefits on your work record if you're found to be disabled. Okay. Now I'm going to jump across the screen and talk a little bit about SSI benefits, supplemental security income. Very different. I like to debunk the myths about SSDI versus SSI when I speak to audiences, because there's a lot of misinformation out there about what benefit is, when you would apply for both. First of all, there's no reason not to apply for both SSDI and SSI, because all it is checking a box on the application, and it's potentially additional benefits you might be able to receive if you happen to be eligible for example, SSI. If you're concurrently eligible, they don't stack them on top of each other, right? So if somebody meets the income requirements for SSI, and I'll talk about what those are, and they also have the work credits for SSDI, you wouldn't get the maximum SSI benefit plus the maximum SSDI benefit. But especially where I see a lot of crossover is when somebody has worked and paid into Social Security and they become eligible, but there's a 5-month waiting period, which there's actually a lot of push in Congress right now to try and eliminate the waiting period for disability benefits. But people have to wait 5 months to receive SSDI benefits from the time that they're found disabled. But with SSI, there's no waiting period. So often, people will be able to receive some payments from SSI while they're waiting for their SSDI benefits to kick in. Let me talk about the SSI a little more, though, before I talk about the interplay between them. First of all, to debunk those myths, hear a lot of people come to me and say, well, I want the benefit that's the long-term one, not the short-term one. So a lot of people think that SSDI benefits is like a long-term disability and SSI is a short-term disability. That's not accurate. The definition that I provided you on the previous page of what it takes to be found disabled is the same, regardless of which type of benefit you're applying for. Okay, so what you've got to be disabled for a continuous period of 12 months or more, regardless of which benefit you're applying for. A lot of people will say to me, I don't want the one that's for mental health. I want the physical health one. Again, the definition is the same for both. What the real difference between the benefits is, unlike SSDI, where it's based on your work history, you don't have to have ever worked at all to receive SSI. The catch is you do have to have a limited income and resources, okay? And here's another place where there's a big push to change these numbers. With SSI right now, if you have assets of greater than $2,000 if you're a single individual, or $3,000 if you're married, $3,000 in household assets, you're unable to receive SSI. Those numbers are so low. And people are shocked when I tell them that those amounts were raised last during the Nixon administration. So, think about what you can get with $2,000 now versus what you could get with $2,000 in 1974. Quite a big difference. Which makes sense for why there's really a push to change the amounts. SSI also limits, there's some exceptions for different resources, because like I said, you can't have more than $2,000 in assets. They're not going to look at the value of your home if you own it and you're living in it, right? So if you are living in a house that you own, that's not counted as one of the assets. It doesn't matter if you're living in a $4 million mansion. If you own it, that won't be counted as one of the, disqualifying assets. They're not going to look at the value of a car if you're using it for medical transportation, 2 cars in a married family if the cars are being used, just to take you to the doctor. Again, doesn't matter if you have a Porsche or a Mercedes. If that car is used for medical transportation, that's not a countable asset. However, if you have an extra car, even if it doesn't work, or you have a motorcycle or a boat, those are vehicles that Social Security will count as assets. And even a car sitting on your driveway in your name that has doesn't run, the parts are probably worth more than the $1,500 maximum. Actually, when I was saying $1,500, then the $2,000 maximum value there. So, you know, it's pretty hard to help someone with SSI if they have multiple cars in their name, which a lot of people just have junkers. And that's common. So those are things to keep in mind. While Medicare comes with SSDI, SSI comes with Medicaid. When I started practicing years ago, the Medicaid for many people is more important than even the receiving SSI. You know, now, at least in Ohio and in many states, you know, around the country, there's been Medicaid expansion. So anybody who falls under the income threshold that would be the qualifier for SSI would also be eligible to receive Medicaid in their state. But there's many states where it's still not just an automatic entitlement. Florida and other places where the Medicaid that comes with SSI is crucial for people because it allows them to see doctors, get their symptoms taken care of. The amount of money that you receive for SSI, it's actually fixed by statute. This year it's $841. However, even though it starts at $841, there's a few potential ways that amount gets reduced. First, for every $2 that you earn from working, because you can work and receive disability, but for every $2 you earn from working, $1 comes off your SSI payment, okay? The other thing that we see happen a lot that people scratch their heads about is like, wait a minute, I don't get it. I was awarded SSI, but they're only giving me $560 per month. Because it's a need-based benefit based on limited income and resources. If you are living in someone else's home and you have food and shelter provided to you, Social Security can deduct up to 1/3 of the benefit amount, which is why I threw out that $560 amount. I'm doing quick math in my head, to account for the fact that you don't need the full $841 because you have food and shelter provided to you. So they're kind of tricky with the way that they do that. They used to not care and look that much. I mean, pretty much everybody was getting the full benefit amount. I will say in the last 5 or 6 years, more of my clients end up having that food and shelter, you know, deduction taken out of their SSI than get the full amount. So they've really come down hard on that as a way to try and find program savings. And then the other difference, which I already kind of highlighted for you, is that back pay begins the month after an application is filed. So if one of us were to walk into the Social Security office today and apply for disability, the first potential month you could receive a check would be for November of 2022, regardless of how long you've been disabled for. There are no dependent benefits for SSI either. You get only the individual recipient receives them. So there's nothing additional for kids under the age of 18. There's nothing for dependents. This is the part where I'm going to spend the rest of my time until I open this up for questions, because I really want to talk about what are the most important things that you can do to receive benefits and keep benefits. Okay. First of all, I believe that the most important thing that you can do, and I'm going to actually, before I hit on the point, I'm going to talk about what I think is the most important part of any case, period. It's all about medical records. People don't get approved for disability because of what they tell me is wrong with their impairments if I'm representing them as their attorney. They don't get approved for disability because of a way that they fill out a function report that's sent by Social Security, you know, whether it's when they're trying to receive the benefits or an updated function report after they're receiving them. Cases are won, lost, and benefit continuation depends on the information that is contained inside of your medical records. Medical records are everything. You know, I tell clients sometimes, especially early on in the case, before I've had an opportunity to see the records, people say, so what do you think? Do I have a good chance? And my most common response, and it's a line that I give everybody, but it makes sense because it goes across the board, is your case is as strong as the communication that you have with your doctors. Based on what you're telling me is wrong, it certainly sounds like you have limitations that are supportive of a total inability to work. But if you're only telling me this and you're only filling it out on the paperwork that Social Security sends, and when you have a doctor's appointment, you're not reminding and repeating them of all these same things, you don't have any case at all. I could be the greatest lawyer in the world, but if I don't have medical records to support the benefits, I cannot help you. So now that having started there, I think it makes a good sense to, kind of launch and having a positive patient-provider relationship, I think is the most helpful and important thing because of how important the medical records are. I have a lot of clients who will say, boy, I heard this doctor is great, but when I go and see him, he never listens to me. He's never writing anything down. He's not really changing my treatment around that much. Having a relationship with your doctor where, one, you're comfortable telling them all of your symptoms, and two, you're aware, you feel like you're in a partnership with them, that they're just as invested in your health as you are, I think is tantamount to winning one of these cases. Because if you're stuck with somebody like my clients complain about, where I go to the doctor, but he doesn't write anything down, he doesn't listen to me, he never wants to change anything, that's not going to be helpful. Because even if you're doing the things that I would tell my clients to do, like, for example, if you're going to you should be letting the doctors know how you're limited day in and day out. Okay. And I'm kind of hitting on the next point here, the next bullet point here, as if they go together, and they really do. Every single time you see the doctor, you need to be letting them know about how your functional limitations impact your ability to do either work activities, if you're working part-time, or how they impact your ability to do day-to-day activities if you're not working. They're going to automatically take your blood pressure. And there's a list of questions that doctors just, as in due course, are going to run through and ask pretty much everybody that they see. They might not ask you if you spend a portion of your day raising your legs, if you need to be in bed for for a chunk of the day to control your symptoms. They may not ask you, are you doing any of the cooking in your house? Are you doing any of the cleaning in your house? Are your symptoms limiting your ability to do those things? Probably no doctors are doing that. But if you're not telling them, then the odds of the medical records lining up in a way that's helpful to you are going to be greatly reduced. Okay. I like to try and explain to people why that happens, right? I have clients that, right, and it's always a quick conversation that I have with a new client. Oh, I know my doctors know what's going on. My medical records should be fine. Have you seen them? Because so often what I find when I look in the records is the clients just assume that the doctors are magically writing down all of their symptoms and limitations. And it doesn't happen that way. So if you're not actively telling the doctors what's going on with you, part of it helps them treat you. They don't know to order another test. They don't know to change a medication around if you're not telling them how limited you are. And so it's just so crucial that at every single appointment you have, you're really letting them know about all your daily symptoms and functional limitations. And them writing those things down is crucial. Now, disability is a vocational question. And I'm trying to line this up for you so you can see why the medical records themselves without additional comparison points like I'm in bed a lot of the time. I can only stand for short durations before I start to feel fatigued or lightheaded. Disability is a vocational question. So whether somebody can work or not isn't easily answered by the outcome of a tilt test. It's not easily answered by what your blood pressure is. There are many people who are going to be very symptomatic on a tilt table test, or, they're going to have, a blood pressure that's way out of whack. But when they're receiving appropriate treatment, it stabilizes their symptoms enough that they can work full time. I'm probably a good example of that, just with a different impairment than many of you on the webinar today. So to kind of bring those two things together, if you have a vocational question, but all you have is medical records, how do you make them line up? You need to be bringing vocational terms into your medical records, and your doctors aren't going to do that on their own. So you need to say, I'm limited in how long I can stand and walk for. Those are vocational limitations. But if you're not telling your doctors, all they're going to do is take your blood pressure. And it's important that all of the ducks line up that way. I think I've talked enough about the first 2 points. And again, I'm trying to get through this enough that I leave you guys time to ask me questions, because I'm sure your questions are varied. Conscientious form filling. I can't say this enough. A lot of times people say, first of all, way too much when they're filling out paperwork for Social Security. I am so guarded about the paperwork that people fill out that if you hire, my office, for example, I don't let my clients speak to Social Security at all. One of the things that we tell our clients right away at the beginning of a case is, if anybody from Social Security contacts you, you tell them they need to call me. Say nothing more. If you have questions about your case, don't call them. Don't call them to give them updates. Call me to give me updates, and I'll relay the updates to them. And any paperwork that pertains to your case should come back to me. It should not go directly back to Social Security. Why is that? The forms that Social Security sends to be filled out as it relates to the disability case, they're not looking at those forms to say, oh, well, the person reported here that they can't stand and walk long, so we're going to include that. I've seen this time and time again. Those forms that they send people to fill out are used to deny benefits. They're looking for you to quickly fill out a form where you say, oh, I have no issues with my personal care. So, a common symptom for a lot of my clients with dysautonomia is that they struggle in the shower, because the heat in the shower makes them very dizzy, and they have to limit how long they can be there for. But when Social Security sends them a function report that asks about any limitations they have with bathing, they just check a box quickly that says, no problem. And by doing that, what you're doing is you're giving them ammo behind the scenes at the first few levels of a disability case. But even worse, on paper, judges will cite to this in unfavorable decisions 2 years down the line. They'll say, person reported that they were able to prepare meals, they were able to engage in unlimited social activities, that they could, shower themselves without a problem, things that are inconsistent with the degree of limitations described elsewhere, like at the hearing, right? Every client that I've ever had is going to tell a judge that they have the symptoms that line up that led to them, that lead to them being unable to work. But if you're not telling your doctors that, first of all, but second of all, if you're not really thinking about what these forms are asking and how they're going to use them, then you're going to just give them reasons to deny you. So, a great tip that I like to give people, when Social Security asks on a function report, can you cook? Can you clean? I always tell people, reverse those questions in your mind. Instead of seeing the question as it's written, see it as though it's written as, How do your impairments combine to limit your ability to cook and clean? Oh, well, I need to keep a chair next to the stove because I can't stand long enough to prepare, a full meal for myself or my family. Or I can't even do any type of, cooking anymore. Instead, for me, meal prep is doing, making a bowl of cereal or putting something in the microwave because that's all that I have the exertional tolerance for now. So think about how they could use those forms against you, because believe me, that's what they're there for. They're not there because they're going to read what you say is wrong with you and find a helpful way to approve you. Moving on here, adhering to deadlines. This is the big one. A lot, I would say probably half of my firm's new clients or more are people who have applied for disability in the past and just when they got denied, gave up, or they didn't really pay attention to the fact that you only have 60 days to appeal an initial and reconsideration level denial in a Social Security case. Okay. You must follow those deadlines. There was a lot of flexibility with COVID. That's kind of disappearing now as things normalize. But first of all, always appeal. Don't just reapply if you get denied, but follow the deadlines. And I don't want to just say that last thought as an afterthought. I want to make sure you guys understand. Keep a disability case moving forward. Don't just do a new application because they invite you to do that on your denial letter. File an appeal. I didn't include this slide here, but to just give you a little bit of a breakdown, okay? Of the initial applications that are filed at the Social Security offices, only about 25 to 30% of them every year get approved at the initial level. That means 70 to 75% of people get denied right away. That is not because those people are all not disabled. And you filing a new application instead of appealing probably isn't going to increase your chances of being approved. So you file an appeal. The next appeal is called a request for reconsideration. There's a few states that don't have that level, but I think 42 of them do now. So we'll act like it's a given. And the numbers that Social Security published last year was that only about 9 or 10% of the reconsideration determinations were favorable. So most, like 90% of people get denied a second time. But then if you file another appeal, which is a request for a hearing, which is where you present arguments to a judge for why you meet that standard for disability that I described earlier, the approval rate is like 50-55% nationally. If you have strong medical records, and many people don't, you have a realistic shot of getting these benefits if your medical records are reflective. But the key is you need to keep the case moving. You need to adhere to those deadlines. Next thing I want to talk about is know what the disability definition for Social Security is. I already provided that at the beginning of the presentation, and I may get some more questions about it. But there's a lot of other definitions for disability out there, but this is the only one that applies to these benefits. The Veterans Administration has a totally different system where somebody can be 20% disabled. Workers' compensation in most states has systems where people are 72% disabled. With Social Security, either you are unable to work at SGA for 12 months or more, or you're not disabled at all. So you need to know what you need to prove in these cases. Finally, and I'm coming right up to 7:45 Eastern time to give us some time for questions, but patience and understanding. These are slow cases. I described how most people get denied and need to file appeals. I see that with this community probably even greater than the percentages that I threw out to you, okay, because they're they're misunderstood diagnoses. But these aren't fast cases either. From beginning to end, a typical disability case, depending on where you are in the country, takes anywhere from 1 to 3 years. So if you don't get approved at the initial level, which is what you should expect, expect that it's going to be a long waiting process, but you still should focus on keeping your case moving forward, because that's the best thing that you can do. I'm going to leave up contact information here so that you guys have it and you're all able to. I put up the email address that I have for the disability education project I have with Jen Morgan, who unfortunately couldn't present with me today. But you know, you can also reach out to me just through my law firm email address, which is Liner, Michael, like M as in Michael, Liner @linerlegal.com. And I'm happy to answer any additional questions you have that I may not have time for, because I see we have 18 of them. So let's, I'm going to stop sharing this screen for now. Should I leave it up? Are they going to be able?
You can take it down because they'll
Okay.
get the recording of it too, so then they'll have it.
Cool.
Yep.
So grill me.
So we have some great questions coming in. I see a lot of people are asking about how you deal with medical records and making sure that they're correct if you see errors in them. So I'm sure Michael has some answer for that, but I also want to remind you on the 20th, we're having another webinar that is all on HIPAA. And in that, we're going to talk about how to handle an issue in your medical records and requesting that it be changed too. So make sure if you're interested in that, you sign up for that webinar. But do you have any details or kind of tips for how to communicate with your doctors and make sure that really what you're saying to them is getting across into what they're writing?
Okay. And I love addressing this, especially because I think that this is probably something that at the time when we did our last webinar was so early on in the pandemic, we hadn't even realized the benefit of this. But COVID has been terrible for many people. There's also some blessings in it. And a perfect example of that is in medical records, believe it or not, because now what I am seeing like tenfold from before the pandemic is a transition to electronic medical records across providers. So before, a lot of hospitals, their doctors' offices were just pen and paper. Now it's rare for me to see doctors still scribbling on paper. Pretty much everybody is using an electronic medical record, but also what they're doing is they're giving you portal access so that you can get messages directly to your doctors. Okay, so one, if you're aware of the fact that you have medical records that maybe there's inaccuracies in them, documenting them by sending a message through the electronic record portal. One, it gets it to the doctor or whoever is seeing it outside of an appointment where it might not be the right occasion to bring it up. But two, your messages usually get sent and are included in a part of your entire medical record. So if you know that there's an inaccuracy, you have the opportunity to send an electronic message to the doctor that says, boy, I see on my chart, that's one of the portals that's common. So I'm just going to use that one. I see on my chart, it says that, you know, I told you this, I didn't tell you that, or maybe it was like, you know, 12 months ago where I was able to work and play with my children. What I said at the last appointment was that I, you know, was spending most of my time in a reclined position trying to deal with my symptoms or whatever the case may be. Well, now you're almost contesting the record in the record. So it's not just out there for the doctor. Hopefully they fix it, but even if they don't fix it, it's documented that you're telling the providers that they're misunderstanding what's going on. This, because of the availability of these portals, though, I'm going to add a point to the question. You know, you may, if you're going to see a cardiologist or a neurologist or even your primary care physician, whoever's managing dysautonomia for you, okay, you might only get 15 minutes with the doctor, which is not enough to tell them all the things that I told you are important that you tell them every single time you see them and have, you know, address what the doctor wants to address with you. But with electronic medical records, what you can do is send them updates about how you're functioning day to day, and again, have that included in the medical record. So it doesn't matter if the doctor's not the one writing it down. If you're consistently telling the doctor what's going on, it's going to open a dialogue too. But then that's a great opportunity for you to say, hey, I wanted you to know, doctor, I had a really rough weekend this past weekend. I noticed that I was just fatigued the entire time. I wanted to let you know that, so that if there's any changes you think need to be made, you can make them. Well, great. Now I've got it documented that you had problems last weekend, and it's not just you at a disability hearing telling the judge that, boy, there's times when I'm really fatigued and I can't function. But they're hearing it there for the first time, or maybe the doctor won't write it down. Now it's in your record and you can place it there. So that's one of the blessings from COVID. And I don't think we talked about that a few years ago because it was too soon for us to realize the prevalence of this.
Yeah, I agree. I think that's one of the things that's really changed for the patient landscape, is having that kind of direct communication and documentation of it.
Yeah.
Let's see. So we got people also asking, do you have to show that you can't do any job in your field, or that you can't do any job at all?
I want to remove the word field. Oh, okay. Well, I guess the second part of the question. In the strict definition, you have to show Social Security that there is no work at all that you're capable of doing. If you could, for example, do and this is an area where I run into issues with, clients with dysautonomia a lot, where a lot of judges will say, well, just sit down all day. There's plenty of what they call sedentary jobs that you can do. It doesn't matter that you worked in a field where you had to be on your feet all day moving around. If you're able to sit in a chair sorting nuts and bolts, then then you're able to work. Now, there's a few exceptions to that, but they have to do with age. When somebody turns 50 years old, you don't have to demonstrate that there's no work at all that you can do. You have to demonstrate that you can't do your past work, and that there's no work that you've acquired skills that would transfer to a sedentary position. And then what you also have to prove is that you can't do more than sit down work. When you turn 55 years old, it becomes even a little bit easier than that. I'm happy to answer questions about the age things, privately if people want to ask me about them, but I don't see it that often in these cases, to be honest. Usually people coming to me with dysautonomia are diagnosed much earlier in life, and that's when they're applying for disability benefits. I see it a lot in people's 20s and 30s, sometimes even earlier now. And so those special grid rules don't factor in that often. Which is why an example that I gave earlier is about leg raising, because I know that that's something that doctors are always telling people to do if they have a dysautonomia diagnosis, depending on what it is. Some people need to do it more than others, but you can't do sit down work if you have to have your legs raised at your workstation. Imagine, how could you do a job seated if your legs were, raised to heart level, which is what they'll tell you to do? You couldn't perform the functions in front of you in most cases. And so that's why I kept giving that example, by the way. But so I hopefully I answered that question.
Yeah, that's great. A lot of people are asking, how do you decide when to apply? So if you are working full time and then starting to have issues, do you apply once you start having symptoms? Do you need a diagnosis before you can apply? Kind of what's your advice there?
You do have to have you can't apply for disability with symptoms. You can't apply. Social Security won't grant benefits because somebody is fatigued and dizzy and in pain. They will grant disability benefits because they have a medical diagnosis, like POTS, or it can be anything, but it's got to be an actual medical diagnosis, not just a symptom. And because of the limitations, but those symptoms can be why the person can't work, even though you do need to have that impairment established. Now, the timing of an application. I'm glad people are asking this question. One of the things that makes me cringe a little bit because of how how much more challenging it is to help someone. We get a lot of people that call the office and say, boy, I was just diagnosed with, a particular impairment. And so, I'm quitting my job. I need to apply for disability. Don't do that. To win a disability case, you need to have, it's not just about a diagnosis, it's about those functional limitations. And I'll take it a step further. You have to demonstrate that despite receiving appropriate treatment, you are still unable to work. So, when somebody just gets diagnosed and then kind of gives up and applies for disability like that, they're going to have a really hard time winning their case. What I like to see is when somebody has been working with their doctors, trying different things. Maybe they're, messing with their sodium levels. Maybe they're, they're trying whatever their doctors are recommending gives them the best chance of improving, and they still can't work. So you need to be working with a treatment team for a while before. Otherwise, just the documentation supporting benefits isn't there, or Social Security will say, well, if you just followed what your doctor said for a while, your symptoms could improve. And that's enough for them to deny it.
Right. So we just got an ICD code approved for POTS that just came out on October 1st. So patients are asking, should they be sending that code to their doctors to make sure it's included in their appeal? Like, does it help to have an ICD code when it comes to disability claims?
It's not about a code. POTS is a severe impairment. I mean, postural, orthopedic, tachycardia. I mean, I see that listed out by judges all the time as being a severe impairment. So that's enough. You don't need to give them an ICD code.
Okay, great. And then I get this question a lot when I'm talking to patients. They get very stressed out about marriage. And so if they marry someone, how does that affect their disability benefits that they're receiving?
Okay, I'm going to get in the weeds a little bit here. The most basic question is, if you're applying for disability benefits on your own work record, so you're applying for SSD benefits on your own work record, marriage doesn't matter because the assets of your spouse don't matter. However, with SSI, it matters a lot because half of your spouse's income gets attributed to you. And so if you have a spouse who is earning $100,000 a year, even though you can't work, if you don't have enough quarters of coverage to be eligible to apply for disability on your own work record, the way Social Security figures it, it's like you have $50,000 a year in income, which totally wipes out any SSI payments. So marriage can have a big difference, can make a big difference there. I think it's better to be basic and answer specific questions if people have them.
Yeah, I just think people don't always understand that the things are different. So it really depends on which type you're applying for.
Yeah.
Do you think Social Security SSI benefits are worth it if it's so limiting on salary capping? I know that's kind of a hard question to answer.
I think if you can't work, every dollar helps.
Right.
So I don't know that I would evaluate it as, the worth. I think that if you need it, you need it.
Yeah. And I think the important thing to remember there too is not to give up. You already reminded people that earlier. Right. But I think maybe part of that question is, I'm exhausted from applying all these times, doing these appeals. Is it worth me continuing to push? And I think the answer is, if you need it, you need it, and you need to advocate for yourself. Yeah,
I mean, there's some people that it might not be worth it to if you have a wealthy family member that's supporting you. But if you don't have that, you do what you got to do to survive.
Yeah, absolutely. Well, Michael, thank you so much. We are getting right up on 8 o'clock. We also want to thank King & Spalding, who generously supports our Know Your Rights webinar series.